Good morning, this is your Kelso Report for Wednesday, September 7th, and I'm your host, Clark Kelso. Individual land use decisions are usually made by administrative agencies such as city or county zoning administrators or a planning commission. But when a decision is controversial enough, a city council or county board may get involved. When that happens, the likelihood of the council or board failing to strictly follow normal administrative processes is heightened, since the council and board usually deal much more with politics and public hearings than with the requirements of administrative law. In West Chandler Boulevard Neighborhood Association versus City of Los Angeles, the 2nd District faced exactly this scenario, where a particularly controversial land use decision made its way up to the Los Angeles City Council. Consistent with the way a city council usually operates, one of its members had forged a compromise position that a majority of the council approved. Unfortunately, the council's only administrative authority under its own municipal code was to review the decision of the planning commission, and it was required to, quote, make its decision based on the record as to whether the initial decision maker erred or abused his or her discretion, close quote. In addition, under the California Supreme Court's decision in Topanga Association for a Scenic Community versus County of Los Angeles, the City Council was required, quote, to bridge the analytic gap between the raw evidence and ultimate decision, and to show the analytic route the administrative agency traveled from evidence to action, close quote. Well, the City Council neither stuck to the record nor explained how it bridged the gap. It seemed to have found a political compromise and approved it. As a result, the 2nd District granted a writ of mandate directing the council to follow its own municipal code dealing with administrative review and to comply with Topanga. I'm sure the attorney to the Los Angeles City Council must feel like she is herding a large number of cats to get compliance with basic rules of administrative law. Next, in Diaz versus Brewer, the 9th Circuit upheld a preliminary injunction issued by the District Court to prevent an Arizona law from taking effect that would have terminated eligibility for health care benefits of state employees' same-sex domestic partners. The plaintiffs brought their claims under the Equal Protection Clause. The case is a nice mix of two hot topics: health care reform and same-sex relationships. Both the District Court and the 9th Circuit applied rational basis scrutiny to the Arizona law, while noting that, quote, such review is more searching when a classification adversely affects unpopular groups, close quote, citing Justice O'Connor's concurring opinion in Lawrence versus Texas. This slightly heightened review, or what some would call rational review with bite, made the difference in this case, because it gave the District Court and the 9th Circuit the ability more easily to reject the state's proffered justifications for the differing treatment, which ranged from a conclusory allegation that the law was an attempt to reduce state costs, even though the state could produce no evidence of what that reduction was, to a claim that the law was intended to encourage marriage. The 9th Circuit approved the preliminary injunction. Now for our one-liners, we begin with the standing case. In Carrico versus City and County of San Francisco, the 9th Circuit held that a landlord's association lacked standing to raise a constitutional challenge to portions of San Francisco's Proposition M, a popularly enacted amendment to the city's rent stabilization ordinance, which prohibited residential landlords and their agents from attempting, quote, in bad faith, to coerce the tenant to vacate with offers of payments to vacate which are accompanied with threats or intimidation, close quote. The complaint did not allege any facts at all suggesting that any of the plaintiff's landlord members ever engaged in conduct that even arguably came within the ambit of this language. No doubt because no landlord wanted to admit publicly that it was engaging in threatening or intimidating conduct. Problem was, absent any allegations that the ordinance would cause any plaintiff to do anything differently, or that it prohibited current or anticipated future conduct, the Ninth Circuit held that standing was lacking. The best the plaintiffs could do was to allege that, quote, Proposition M was intended to and does impact our members' operations as landlords, close quote. The Ninth Circuit rejected this allegation as, quote, conclusory and insufficient to establish standing, close quote. Consistent with Article 3 standing requirements, something more concrete and particularized was required. Next we turn to habeas corpus, where in Ybarra versus McDaniel, the Ninth Circuit denied habeas relief in a 30-year-old Nevada conviction for murder and rape resulted in the death penalty. The death resulted in imposition of the death penalty. The defendant completed his first round of state post-conviction remedies 2 decades ago. The 1990s were spent bouncing back and forth between federal and state court, with the federal court trying to get the defendant to exhaust his state remedies. State remedies were fully exhausted a decade ago. In rejecting his federal habeas petition, the Ninth Circuit held that some claims were procedurally barred by state law, although 2 claims, believe it or not, remained unexhausted. That is, deprivation of right to an impartial jury and prosecutorial misconduct. Well, the Ninth Circuit addressed both of them on the merits and denied both of them. And the defendant's claim of instructional error, jury instructional error, was harmless. So, the defendant's next stop in this 30-year journey is to file for in-bank consideration, which probably will take another year. Let's turn to insurance. In Felden versus Illinois Union Insurance Company, the 6th District held that summary judgment was properly granted to the insurer in a duty to defend and coverage lawsuit, where it was clear that the claims made in the underlying litigation were excluded from coverage. The duty to defend is triggered only if the underlying suit potentially seeks damages within the coverage of the policy. The court found that none of the underlying claims were covered because of an exclusion in the policy for, quote, interrelated wrongful acts, close quote. This exclusion provided that if more than one wrongful act had a common nexus of fact, circumstances, events, or transactions, all of those acts must be considered as one claim under the policy, and the claim shall be deemed to have been made when the first wrongful act occurred. Analyzing the complaints in the underlying action, the court determined as a matter of law that the interrelated wrongful acts clause was triggered. And since the first act occurred before the date of policy inception, there clearly was no basis for coverage and no basis for a duty to defend. Now to consumer protection. In Joyce versus Ford Motor Company, a jury found against Ford on claims arising under California's Song-Beverly Consumer Warranty Act. The claim was that a new Ford 250 diesel truck sold to the plaintiff had mechanical problems, which Ford dealers had been unable to service or repair in a reasonable manner over about a 2-year period, thereby triggering the refund or replace remedies of the Song-Beverly Act. Notwithstanding the jury verdict, the trial court granted judgment to Ford as a matter of law, based on Ford's contention that the act only covered vehicles, quote, bought or used primarily for personal, family, or household purposes, close quote, and the plaintiff's vehicle was used for business purposes. Well, the 3rd District reversed. Ford had given an unqualified admission during early discovery that the vehicle was a, quote, new motor vehicle, close quote, as defined by the Song-Beverly Act, which, given the definition in the Act, amounted to an admission that the vehicle was used for personal, family, or household purposes. So even though the evidence in the case was that it was used for business purposes, Ford had admitted that it was used for personal, family, or household purposes. And the court didn't want to give Ford a chance to go back on that admission. And in any event, the court also found the vehicle weighed less than 10,000 pounds, and the exception for business vehicles applied only to vehicles that weighed more than 10,000 pounds. the 3rd District reinstated the jury verdict. And that's it for today's Kelso Report. Have a great day in the law.